Well, hello there, ladies and gents. Great to see you again, and welcome back to Lessons by the Lake, the Oswego Private Wealth Show. I'm Ryan Ruff, your moderator, but as always, I'm going to be joined by really the star of our show. That's Bob Bedraitis, the managing director over at Oswego Private Wealth, and we're going to be jumping into a really great conversation today. If you're a frequent, viewer, listener of the show, Bob and I have a lot of conversations surrounding the entrepreneur, the business owner, because Bob is best known for helping those folks become financially independent of their business and ultimately helping them to maximize their life's work at the end of the day. So today we have a really interesting conversation that is centered, yes, around those business owners, around those entrepreneurs, because something's coming. There's something important that we need to keep our eye out for and something we could be doing. We should be taking measures right here and now to prepare for that thing. What am I talking about? Well, today's episode is entitled, Are You Prepared for the sunsetting of the estate tax exemption? So with that being said, our topic is obviously going to be diving into the sunsetting of the inheritance tax at the end of the year 2025. And of course, the planning that high net worth individuals and families and those business owners and entrepreneurs that we talk so much about should be considering in the here and now. And on top of Bob and his wisdom and expertise that he brings to the table, we've got another guest lined up that's going to be joining us today. Today, we have Kristin Gaston, who's stopping by the show to share her wisdom, her expertise, and her kind of angle coming into this conversation, given her background as an estate planning attorney with Generations Estate Law. Kristin's going to be able to provide some of that context, in between the lines, if you will. Bob will work in from the wealth management side, and we'll have a really good analysis of this, this sunsetting provision that we should all be on the lookout for. So before we bring Kristin on and get into the nitty gritty of everything, let's go ahead and say hi to the man of the hour. Bob, good to see you today. How you doing?
Ryan, good to be here. Always awesome to see you.
Yeah, always a good time when we get together. We've got a big topic. It's kind of at the forefront of concern for a lot of those business owners and entrepreneurs out there. And as I mentioned a moment ago, there's stuff that they could be doing in the here and now. But before we get into all that stuff, we've got Kristin Gaston joining us today. Why don't you just share with us, why do we want to bring Kristin on? And what's your relationship with her?
Well, first of all, we wanted to bring Kristin on is because she's awesome. And Kristin and I have known each other for a few years now. We're actually a part of a roundtable group where we get together with other CPAs, business attorneys, property and casualty folks, executive coaches, and we talk about anonymously, we talk about our practices, our clients, and how we can best serve them under the virtual family office model. So Kristin and I have been doing case studies together, talking about mutual clients. And so I've really gotten a deep understanding of her professionalism and how excellent an expert she is in the area of estate planning and estate law. And so I couldn't be more excited. Kristin and I have been talking about doing this particular podcast episode for some time now. And I think this is one of the most timely episodes we've had yet on this show. So if I could back up just a little bit before I introduce Kristin and give you the hopefully not too boring history of the estate tax, the inheritance tax. So the inheritance tax first came to the United States in 1898 as a way to pay for the Spanish-American War. When the Spanish-American War was over in 1902, it was repealed. The war is over. The Congress no longer needed this special tax to pay for the war. Well, fast forward to World War I. In 1913, they began the estate tax as we know it to pay for World War I. Well, here we are, 111 years later in 2024, and the tax is still going strong. So either Congress wasn't completely honest with us that this was a temporary tax, or to those who are alive in 1913, or the war is still going and I'm just not aware of that. The other thing that's really interesting is the runway that we have. So the estate tax at its current amounts, and Kristin will get into kind of details on what those numbers are, but it's a pretty big number. If you have an estate up to $26 million, you have an opportunity to transfer that estate tax, husband and wife, roughly 13 million each. I think it's 12.92 million each, roughly 26 million to the next generation without being leveled that inheritance, that estate tax. Well, that is set to sunset January 1st, 2026. So we have, through 25 to do the planning that Kristen and I are going to dwell very deeply into in order to reduce that tax. But with that said, I think there's so many people that are procrastinators, and I believe they're going to find in the second half of 2025, they're going to find that number one, they probably won't have as much runway as they thought they had, and number two, estate planning attorneys around the United States are going to be swamped, and it's going to be a rush for the exits at that point. So the other thing about that runway that I think is amusing to me is in 1993, Kristen, you may remember this, but Bill Clinton found a way to increase the tax rates in September of 1993, and they went retroactively back to January 1st. Well, that means that he found a way, which is genius. It's just genius for our government to get revenue. They found a way to tax the dead. So if you died between January 1st and September 1st under those rules, you thought your family was in good shape, and this new tax showed up, and people who had been deceased for a while now found that their estates were ending up paying those taxes. This is different. This is different because we were told well in advance that the sunset is going to occur January 1st, 2026. So we have time to do that planning now. So anyway, that's my preamble on why I think this is such a significant thing, because rarely is there a chance to have a 40% plus return on the money you want to pass on to the next generation by simply doing thorough and complete and thoughtful planning. And we have that opportunity now. So that's why I believe this is so timely. That's why I believe that this is an issue for us to get into now. So Kristen is with Generations Estate Law. She's a Detroit girl, near and dear to my heart, even though I'm Ohio. Our rivalry's not too big, Michigan, Ohio State. And you can see behind her, she went to St. Olaf College in Minnesota, came out to Lewis and Clark Law School, has lived in a few states and done some really interesting things, and now has established her practice right here in Portland. She does terrific work. I know she's got a beautiful family, still educating them through the high school years. And Kristen, say hello. I'm so happy to have you on the show today.
Thanks, Bob, and thanks, Ryan, for having me part of this episode. It has been really exciting to plan for this with Bob over the last few months. And I wanted to just start by thanking you, Bob, for the opportunity to be part of the roundtable. It has been a really great experience, and the collaboration we have with everybody in that room to talk through these case studies and really become creative with each other about ways to help these business owners think through the various transitions. So it's been a really great opportunity, and I'm looking forward to more of that.
So that's awesome. I feel the same way. I feel it's such a dynamic group, and you're such an important part of it. So I feel the same way. So let's talk about our subject today, Kristen. Let's talk about this estate tax. What should families, business owners be thinking about who are at that $26 million threshold or above, or even if they're above where the new thresholds are going? What kinds of planning things can they? Well, first of all, let's just kind of talk about it on the federal level, and just what do you think? What should people be thinking about? Prospective clients be thinking about?
Yeah, that's a great question, because I think people just haven't really worried about the federal estate tax for such a long time. It has been really high for a lot of families and business owners. 26 million feels like something that they weren't sure they would ever hit. And so even if their businesses were growing and their properties were gaining in value and their retirement accounts were growing, that $26 million number for a married couple seemed pretty far off. So I think for a lot of people, the first step is to really reevaluate your estate plan and see what provisions are in there that might have some flexibility or really need to be changed. And like Bob said, to not put off the idea of getting that conversation going with your professional advisors, because there are a lot of options, and starting that conversation now will give you plenty of time to look at the kind of things that you can do to get yourself in the position where you won't have to pay a surprise federal estate tax at death.
Kristin, where will these numbers realistically come down to in January of 26?
Yeah, what we're hearing is that at the sunset, they're returning to the previous levels, but then indexed for inflation. So the estimate is that it'll be about $7 million per person. So a lot of the conversations today will be about married couples, because there are options for transferring between spouses that we want to talk about. So most likely 7 million for an individual and 14 as a married couple.
Yeah, so if you're in that range between 14 million and 26 million, you may have felt that you were bulletproof and some level, and all of a sudden you're not. Also,
Exactly.
some planning needs to be done, and that's on the federal level. States levy an inheritance or estate tax too, don't they?
They do, and it's just a small handful of states. So for a lot of people well, there are only 12 states that have a state level estate tax. So for a lot of people, that isn't an added planning concern for them. But Oregon and Washington, both of states here where I'm licensed, both of those states do have a state level estate tax, and the exemption is quite low. So the perhaps benefit of being a client in Oregon or Washington is you're probably more familiar with the idea of at least thinking ahead to plan for estate taxes. But now, again, in those states, you still have to think about state level planning and a lower federal planning. There are two different taxes that would apply.
Yeah, and Oregon begins as low as $1 million, doesn't it?
It does. It's really very low. You think about a small business, you own your home, retirement accounts, life insurance, you're very easily over that $2 million threshold as a married couple.
Exactly, and those amounts can get up into double-digit figures, can't they? Those taxes.
Yes.
Yeah, yeah, that's something. So how would I know if the estate tax applies to me? What steps should I be taking as a business owner or a high net worth individual or couple?
For the state level taxes?
Well, for either, yeah, I guess
Right.
for either, if you're under the 14 million, or particularly if you're over the 14 million, what kinds of things should I be thinking about?
Well, the first thing to point out is often people are confused about life insurance because we hear about it so much as a tax-free asset, which is true on one level because it is income tax-free. But when the state of Oregon or the federal government is looking at your assets in order to assess an estate tax, life insurance is part of that. So sometimes we hear the term worldly assets, and so it will include everything. It includes your house, retirement accounts, personal property, life insurance, and businesses. So it's a pretty big net that captures all of those assets.
Yeah, I've seen that so many times. It's not hard to live in the Portland metro area now and have your modest home be $1 million plus home, right?
Right.
Not even, perhaps even a multi-million dollar home. And then you own your other assets, your retirement, your investments, your personal property, and then you have a $1 million life insurance policy. And little did you know that you own that life insurance policy, and Oregon says that's another $1 million we're going to tax. So it's very possible for people who live very modestly and feel that they've done all the work. They have trusts, they have wills, they know how they want their assets to be distributed at their death or disability for that matter. And all of a sudden they're saying, wait a minute, I have a $300,000, a $500,000 tax bill.
Right.
Which leads me to the question as well, is that on some level a voluntary tax? Can you avoid or reduce, can you at least reduce those taxes pretty significantly with planning?
There are a couple of ways to think about reducing. I'm going to focus on Oregon for now. And one sort of analogy that I think helps lay out how the exemption works is to think that in a married couple, each of you have this $1 million credit. It's kind of like a coupon. And so at your death, that first $1 million of assets is tax-free. The problem lies in the situation where when the first spouse dies, if all of those assets are just held by the survivor without any special planning, and then when that survivor dies, to the state of Oregon, it just looks like they're all your assets and you can only apply one exemption. So it's absolutely critical in the state of Oregon to evaluate how to trace assets that belong to the first spouse at death, so that when the survivor dies, the state of Oregon can look at the assets over here. Sometimes it's referred to as a credit shelter trust or a bypass trust that can hold that million, and then Oregon won't tax that trust. And so that's a really core piece of planning for a married couple that has a taxable estate.
I know, and that's such simple, low-hanging fruit that couples don't think about, because they might be thinking, even a couple might be thinking, well, we're under the 14 million, we're at 10 million. So 5 million for my spouse, 5 million for me, and we pass that on, but without a simple bypass trust, credit shelter trust, which is so easy to do. I'm sure you could do those in your sleep. They're pretty simple documents. Without doing that basic estate planning work, when the first spouse dies, now the second spouse has a $10 million estate, of which 3 million is taxable on the federal level and 9 million is taxable on the state level in Oregon. So
exactly right. Yeah.
Yeah. What about other tools? What are other things business owners can do? Do business owners have kind of a leg up, maybe more planning tools available to them on some level?
Yeah, there are a couple things you can do. One particular way to think about family businesses, and this is part of that interesting conversation we have with families that have a mix of assets, is if it is an example where the family business will be passed on to the next generation, then there are options for family business to think about how that change in entity can take place over time, where the current business owners can retain a lot of control and management over the company, but they can begin transferring ownership during their lifetime to reduce what's considered part of their estate at death. So family businesses really do have that creative opportunity to pass the ownership on during their lifetime and still retain control.
Yeah, one aspect that I see very often with our clients is they have charitable intent and they want to magnify those charitable gifts. And we have done planning. We have done planning for clients where if the idea is, well, I have this business worth $30 million, whatever the name is, but ultimately I don't want to. I kind of have the same Warren Buffett idea or the Bill Gates idea is my kids don't need all that money. I'd like to give 25% of it, 30% of it to the charity of my choice. What kind of opportunities are there as they're contemplating the sale of the business in the next 2, 3, 4 years in order to do that and reduce not only their estate tax, but their income taxes on the sale of the business?
Right. So when clients have charitable intent, it really does open up a lot of other opportunities for planning and creative ideas. One of those types of planning strategies is referred to as a charitable remainder trust, or there are various names for that, but we'll just call it a charitable trust. And so the basic concept of that is to make that charitable gift during your lifetime so that asset is not part of your estate and you get a deduction at that time, where ultimately at the end of the ownership, the distribution of that value in the asset goes to the charity of your choice, but you've also been able to maintain some stream of income from that charitable gift. So it has a double impact in that charitable deduction, as well as pulling down the overall value of your estate at death while supporting the charity that you care about, of course.
I know. I mean, I think that's something when we first broach the subject and bring it to our clients, they're just saying, wait a minute, this sounds too good to be true. I can avoid, let's call it 30% for argument's sake. I can avoid the taxes on 30% of the sale of my business. I can take a lifetime income for my spouse and myself off of that money that was never taxed. And then ultimately I can benefit the charity that I care so much about. It's a triple threat, right? And again, it's not for everybody. Again, I think where I see that going in the wrong direction is when the couple truly does not have a charitable intent. whether it's the symphony, whether it's the guide dogs for the blind, whether it's their church, a ministry, that they truly don't have that charitable intent. And I think that's then putting a square peg in a round hole to try to use a charitable vehicle for that. But so many of our clients are generous. I know yours, I know yours are too, and they do have that intent. And it's just such a great planning tool, and just one of many.
Right. Yeah, it is triple threat. I like that.
Yeah. Well, any other things that are relevant? I want to ask you a couple more things, Kristin. I want to ask you other things that might be relevant from a planning viewpoint, or what first steps would be to engage to start having this conversation sooner rather than later, because I do truly believe that the exits are going to have a mad rush for them as people are waking up to them as we get closer to January 1st, 2026, right? And
Right.
and that's number one. And then who should be on that team as they're kind of doing their planning? Who's the CPA? I would imagine, in my opinion, I'm sure you agree with me, should be a big part of that planning team. Wealth
Right.
management, you as the estate planning attorney.
Right. Yeah. One other idea I was getting back to with in terms of planning for business owners, especially, is talking about incapacity planning. Oftentimes we think about death planning because that's where the estate tax is assessed, but it's because gifting can be a big part of the strategy before death, then ensuring that the estate planning documents have adequate and robust and clear gifting provisions so that a successor trustee or a power of attorney on behalf of the business or the other assets in the couple's estate have that flexibility to do that analysis about taxes and all of its various applications. So incapacity planning also really needs to be revisited for that time as well.
Yeah, it's so it's so true, because people are living longer, and they're not necessarily living their final years in the most robust and healthy of conditions. I'm watching, Michelle and I are watching a Apple TV show right now where the matriarch is husband's dead. The matriarch now is in a coma while they're battling over all of her money. So I'm not recommending the show. We only watched the first episode last night, but it's kind of funny. So
Yeah, that's an interesting premise. It's one of those things that, you never want to be in that situation where somebody is in a coma, but it is exactly the situation where somebody who's previously made a lot of decisions and required to be part of decisions and involved in those decisions can be, then what happened.
and we're in incapacity, because we've had a number of clients, I'm sure you have too, where dementia, Alzheimer's becomes an issue, and there's a sadness to that all its own, but it also creates other planning issues.
Right.
Yeah, right. So, well, that's fantastic. I'm sorry. Go ahead. I interrupted you.
Well,
I think.
I was going to answer your second question, which was about who should be on the team, and I agree with you. There's a real opportunity for everybody on the professional advisor team that's working with a family to, if they don't already have one, bring in any missing pieces. So an estate planning attorney, retirement specialist, sometimes depending on unique business owners sometimes have unique retirement accounts and retirement plans, wealth management, business exit strategy, CPA for sure, life insurance can be a critical. Hopefully that's been something that's been considered earlier, but kind of goes back to that idea of planning for the estate tax, is that if you have life insurance that can pay what estate tax will be due, that's part of the planning. So at this stage, sometimes people think that they don't need life insurance for the original reasons they might have considered it when they were younger, but now they want to consider it as an estate tax planning tool. So if there isn't somebody who can take a real clear and detailed look at how life insurance can help, that's an important person to be part of the team as well.
My penultimate question is control and ownership. Many people feel that, and I think incorrectly in many cases, that in order to do really proper estate planning to reduce those taxes, they're somehow giving up control. And as we know from high net worth individuals and business owners and entrepreneurs, many times control is a critical value for them. Is that an issue? Is that an issue, Kristin, or are there ways to do this planning without a couple needing to give up too much control?
That's a really good question. One example to just sort of clarify maybe what we're talking about in terms of control is what I was just saying about life insurance. If somebody needs life insurance to pay estate tax and they're adding it to their estate and they don't want to increase the value of their estate, there's a way to hold the life insurance outside of your estate using an irrevocable life insurance trust. That's the kind of trust that you are essentially giving up control over, but it's also has a very different impact because you shouldn't need to tap into that life insurance during your lifetime. So I do find that for people that consider control to be a big part of their planning, that's an easier sell to make sure that they understand, okay, that life insurance trust isn't really under my control, but I don't need it during my lifetime, so that's okay. So I do find that discussion about charitable giving and transferring of assets or parts of businesses during lifetime is a really nuanced question for business owners, because most of them have gone into business because they have, and through the success of their business, have maintained control where they need to in order to grow a thriving business. And sometimes those people have a hard time giving up the control over their business. And I guess what I would say to that is it's understandable. And what we hope we would be able to do is surround them with people that they can trust, the family members and their extended family and their professional advisors, to not only trust their advice, but trust the people that they're putting in control of the next phase of the plan.
Yeah. Excellent. Well, my final question, my ultimate question for you then is really, if people are motivated by this conversation and know they need to get to it, how would they contact you? How would they get in touch with you? And what would the process look like?
So I think the first thing would be, right, look at the plan that you have, pull it out of the closet or wherever you've kept, I'll do that over. Pull it out of the closet and wherever you're keeping it, take a look at it, see what needs to be evaluated, and ask for an estate plan review. Our firm is doing estate plan reviews. We will go through all the documents that you have and give you our feedback on the areas where we think there could be improvement with relation to anything that's a trustee of your plan or a key individual in your plan who may need to be considered, then of course the estate taxes. So if you have a plan, reevaluating it to see if it's current, and then from that, if not, what needs to be adjusted. People can contact me through my website. We have calendaring on the website, or they can call our office and set up a complimentary consultation or an estate plan review. We find that initial conversation is more personal for clients when we can do a review of some of their goals and previous documents ahead of time. That way we can give them very specific advice and answer their specific questions and leave them with a set of options on how they can go from there.
Yeah, it's perfect. We use the term stress testing, which is our process, the blueprint process of really trying to analyze everything, the advanced planning area. And I think of this as stress testing your estate plan. When did you do it? 2010. Well, things have changed. There have been numerous tax laws. Things are changing again dramatically, as we've talked about on this show. And are you up to date? Is everything in order? And that stress testing is just the stress testing from the estate view, or from my a bit more holistic view. I don't like that term holistic, and I'm using it anyway. But comprehensive view is that we want to talk about those 5 things we talk about a lot on the show that people are concerned with, that have businesses and high net worths, which is am I making smart decisions about money? Well, this is a no-brainer, and make a smart decision. Do this planning. Number 2, how can I reduce my taxes? Why am I paying so much in taxes currently? And my goodness, you don't want to pay so much in taxes after you die, or your kids or your whomever pays that much in taxes later on. Number 3 is taking care of the heirs. This checks that box. Number 4 is protecting those assets against unnecessary litigation and confiscation. And last of all, to the extent that they're charitably minded, to magnify those charitable gifts. So this really checks all the boxes of what we believe that business owner and that high net worth couple and individuals are interested in. And so I am just so happy and want to just thank you from the bottom of my heart, Kristin, for being a part of this podcast and all of your expertise.
Thanks again for the invitation, Bob. It's great to be a part of the conversation and talk through some of these upcoming changes that clients can be prepared for. Like you said, stress test their plan.
Excellent.
Well, and guys, Bob, you're having conversations a lot with clients, not just about the sunsetting of this as we end 2025 and roll into 26, but about a multitude of things regarding their financial world. But aside from that, the commonality that I'm hearing from both of you throughout the conversation is just start this process, start having these conversations, get this on your radar now before, we're nearing the finish line, so to speak. Bob, for anybody out there, maybe a current client or somebody out there that could benefit from even that stress testing process that you had mentioned a moment ago, what would be the best way they can get in touch with you and your team to just start that conversation?
Yeah, please come to our website, oswegoprivatewealth.com. We're also opwm.com. And just come to our website. You also have an ability to have an introductory conversation with me, and just get on my calendar. And I'd love to have that conversation. And Eric and I here working together in tandem, we're both certified exit planners. We love succession planning. We love to help business owners become financially independent of their businesses.
Fantastic. Well, Bob, Kristin, again, thank you so much for your time today. I appreciate you both spending time with us. But as always, we're going to take a final moment and thank you, our audience members, for taking some time out of your days to listen to us today. If you enjoyed today's conversation with Bob and Kristin, you learned a thing or two. I know I did. Make sure you hit that subscribe button on whichever platform you checked us out on today so that you don't miss out on any other great conversations where Bob and I dive into these different wealth management topics. We bring on some great guests today. Again, Kristin Gaston joining us from Generations Estate Law today to bring her expertise to the table as we look at this sunsetting provision. Just a lot of value on the table here with these conversations, and we want to make sure you don't miss out on any in the future. Before Bob and Kristin, I'm Ryan. We're going to go ahead and say so long now, but we appreciate you stopping by and being with us on Lessons by the Lake.